Okay, welcome back. This is Roger Royce. I'm a partner with Haynes Boone, Palo Alto. I do emerging growth and venture capital, and this is the 10,000 Startups podcast. Although today we're going to step maybe a little beyond just startups and talk about corporate governance more generally, especially around what's happened recently with OpenAI and Musk v. Altman, one of my favorite cases, at least this year. I'm really thrilled that we have as a guest today, F. Daniel Siciliano. He is a successful serial entrepreneur. He's a corporate executive, a venture capitalist, an independent director on the board of the Federal Home Loan Bank of San Francisco. He also co-founded and is CEO of Nikkl Inc. And he has, I think you're still an affiliate with the Stanford Law School Rock Center Codex
Sure.
program as well. I mean, I could spend the whole time just going through all of your credentials. Suffice it to say that Dan is an authority on corporate governance and corporate compliance, and I am really interested to get Dan's take and perspective on some of the issues we're going to talk about today. And let me just kick it right off. We've all read in the papers. It's been a little while now. The dust has settled a little bit, so people might have opinions. But the whole OpenAI thing with replacing the board a couple of times, the structure, et cetera. Dan, I'm going to let you maybe just give us some background on what happened there, and then we'll talk about why it's important.
Yeah, so at the big level, kind of the high level, so the OpenAI in its original inception, 2015, 2014, 2015, was created as a nonprofit structure, right? But the OpenAI we know and tend to think of and interact with is a capped for-profit structure, which is separate but controlled by OpenAI in a big picture sense. I'm oversimplifying for some of the technicalities. So if you're like a corporate lawyer, don't cringe. It's a little bit more complicated, but suffice it to say that the board of the nonprofit entity is the controlling board for almost all purposes. And so as of 2019, though, the OpenAI we think of as a commercial entity, became the relevant, highly, highly valuable entity. And Altman, of course, is overseeing both. In short, there was, and the dust will settle, but I think the dust is going to get kicked up again and it will settle again. But in short, there was a divergence in the sense of direction and strategy from the board and Altman. And the board, as it was originally in place, it was a small board. It was people that no one really knew, particularly. No one had been paying attention because it's a nonprofit board. They voted and technically correctly removed Altman as CEO. And they did that in a very short period of time. The notice requirements for that kind of action are a little bit more complicated in the nonprofit space, but in so doing, they set off a crisis. And we all watched that play out in the news. That was interesting. That crisis resulted in effectively the reinstatement of Altman because it jeopardized the entire enterprise, right? The entire OpenAI enterprise, the nonprofit and the for-profit, became unstable. Why? Because it surprised key investors. It upset key employees. You had a potential exodus and kind of, mutiny on the hands of the remaining board at the time. And then, there was concern by the critical partners who, despite all of its success, OpenAI still needed to be able to consume additional capital as it grew. So I'll come back to that because, by the way, the technical, practical issues that confronted that board, whether they are for-profit or non-profit, doesn't matter. The fiduciary duties are essentially the same, and their thinking should have been, I think, just my view, different than what they walked through at the time. And then there are some practical best practices from a procedures viewpoint that they should have engaged in, regardless of what they thought. But that pressure caused the board to be reshuffled, caused some resignations, caused Altman to be reinstated. And then, and you probably are more up to date than I am. I haven't checked in the last week and a half, but there was changeover and movement as to who those directors were. Now, I think who the board is less relevant than the overall expectations of that board and the fact that now there's a lot of scrutiny of the board. And so they are hopefully and likely to engage in a wider variety of best practices. But taking a step back, by the way, this is the OpenAI as a fast growth, cutting edge technology company that is funded, maybe by venture capitalists, but their funding is a little bit more complicated than that, is not particularly different from most technology companies that have had their level of success, who have been on the cutting edge of kind of technological disruption. And that is to say, it is a rocket ship whose captain is a very specific person, and that captain is inextricably intertwined with not just the operational practicalities of the company, but its image, with its morale of its employees, with its expectations of its investors. And ironically, in light of, Musk v. Altman, Elon Musk is the other quintessential example of that, right? So everything Musk is involved with, you have a hard time imagining him not there, even when he's causing problems, right? You kind of think, well, what if they got rid of Musk? And they're like, but would it even be that company anymore, right? And so Altman had the same intertwined coexistence as a person, in what we sometimes governance refer to as an imperial CEO. That's probably not as kind as it should be to Altman, but the fact that he not only was practically calling the shots, but if he wasn't calling the shots, it maybe didn't work because of all the expectations and the culture, et cetera. So that, by the way, seems to have been missed by, we'll call it board version A, right? Like the board version A had critiques and concerns that if you took the time to read them, they seemed like valid points of discussion. Like I don't think anyone who's paid a lot of attention would say, oh gosh, that board was just crazy. I don't think they were crazy. I think they had raised legitimate, substantial concerns that any board should discuss. But then they kind of seem to miss one practical essential element, and that is Altman was OpenAI for many practical purposes, and OpenAI was Altman. They were almost alter egos, right? And to simply fire Altman was not clearly, right, the evidence shows, but was probably not reasonably in the best interest of OpenAI. Right. And if you get in all the fiduciary duties, there's two basic duties and then a couple other things. There's duty of care, duty of loyalty. Well, the practical issue of that is you need to act in the best interests of the organization. And if it's a nonprofit, it gets a little screwy because you've got some stakeholder claims and some other things, but you clearly have to ask yourself, will this help or hurt the organization? And if you believe that it helps, then okay, you're within your rights to do that. But one would question, how did you arrive at that? So let me stop there. That's kind of the setup of what happened, but I think the takeaways are many, and a couple are non-obvious, and those are probably the more valuable takeaways. And those actually tend not to be legal. Like among the two of us, you're the real lawyer. Like I'm a recovering lawyer who became a law professor, who then became a recovering law professor. So I'm like two steps removed, but I can wax eloquently as much as you like.
Okay, well, definitely, we don't want to get too bogged down in the detail. We're looking for the big lessons here, but let me give a little more background. Let me give you, I guess, a practicing lawyer's view of this. We start off with OpenAI, a nonprofit. Much different entity than a for-profit, right? They got a different constituency, they got a different objective, and we've got a board that you'd expect to see in a nonprofit, right? Academics, technical people, et cetera. Yep. Not really people focused on making money. And then what happens is what happens often. I've done this 100 times. It's like, wow, nonprofit, we got something that's actually valuable. Let's spin it off and make some money with it. And then they spin it off. Well, that's a different skill set. That's a different kind of board. Totally get that. What's interesting to me as a lawyer is that there is complexity in this structure that only a lawyer could love. Right. Really, in fact, it's unique in my experience because they use a series of limited partnerships with capped returns for their for-profit investments. And we'll get to the Musk v. Altman case, but one of his big complaints is that, gee, you use my money to build this thing, and then you put it in a for-profit, and you totally abandon your nonprofit purpose that you promised me you were going to, we had a contract, we had an agreement, it's in the emails, you're going to do this with it, this nonprofit, we're going to save the world. And we also have to step back and realize that Elon's view of AI is that it is a potential existential threat, right?
Which is relevant, by the way, because the early funding for OpenAI, the nonprofit, was with that mission in mind, and that funding by necessity, to your point that a nonprofit is a fundamentally different structure, was given as a gift. And those gifts, in turn, were presumed to be utilized to satisfy that broad mission. But in a nonprofit, you can't, until later when they created the capped profit structure in 2019, you can't give a gift in exchange for rights. So certainly not security. So relevant to the Musk v. Altman, there were no securities purchased by Elon Musk. That's a fundamental challenge for his entire line of thinking here, by the way, from a kind of legal viewpoint as a practical matter, because there's no securities claims here, not really, and certainly not formally by him. But and then even further, the traditional method of giving gifts, even to a very directed, mission-driven nonprofit, is not, there are exceptions, is not sponsored research or sponsored projects, right? This is not we're hiring you, giving you 10 or 15, or in his case, 15, then 20, then $9 million, to do X, Y, Z, and here are the deliverables, and here's the schedule, and here's the time frame. That, so far as we know, in the public sphere, is not what was at play at all. And so they were open-ended gifts, which, by the way, just highlights the tremendous power and responsibility of that board of directors, right? So they are stewards of that capital that's been provided to them and have a pretty loose and vague set of, guidelines and rules that they need to adhere to in order to satisfy the reasonable expectations of those donors. But it is not like the fiduciary duties one would owe to shareholders, right? Your fiduciary duty in that story is much more complicated.
Well, let's
me
talk
stop
about
there.
that because Elon did raise, so his lawsuit, number one was a contract claim. You didn't do
Yes.
what you promised, you're gonna do the money. But second, there was a fiduciary claim. Now, I think he's got a standing problem with that, as you've mentioned, like, you're not a shareholder, how do you get fiduciary duties kind of thing? But let's assume we get past that. That's really interesting. Now, what fiduciary duties does this board of this new for-profit now owe? And how does that relate to the fiduciary duties of the nonprofit, which has a big stake in this? And one of his big complaints is that, gee, you had this third party, Microsoft, that had way too much influence on your board. That's something I think we can maybe draw some lessons out of.
Yeah, and I think so. So first, let me say broadly, I think Altman and Musk and the other early players in OpenAI were trying to solve a problem that crops up a lot, which is you have a big idea with a big technological trend, and it has upside and downside and positive externalities and negative externalities. It's early days, and you're trying to put everything in a box that gives you room to not just be profit seeking and balance all these concerns. There's no easy box to do that. There's the public benefit corporation, there's nonprofit structures, you could do unincorporated partnerships with, operating guidelines. You could do an LLC, limited liability. There's lots of choices, but none of them are really purpose built to handle something that could be worth hundreds of billions of dollars, but starts out quite nascent and has all these things. So I do want to, it's not in defense of them, but I do want to say they were tackling a future problem that was really complicated. So when people say, how'd they let it come to this? Well, I think I think there was no easy paths to avoid something like this. So go back to the fiduciary duties. So if you look at traditional 501c3s, so let's keep in mind that a nonprofit is typically an incorporated entity. So it's a corporate entity, and it's probably a Delaware corporation if it's going to be aspiring to be big at all. So the corporate structure is not particularly different. We'll get to ownership in a second. And the 501c3 is a tax IRS designation, right? It's a treasury designation. So those are two things that we then suddenly think of the nonprofit as a 501c3 or a C4 if it's lobbying, or a C6 if it's a trade group. So, but the fiduciary duties are complicated because you have essentially stakeholders who may have certain types of claims. You have beneficiaries, you have people who have contracts. And so there is no shareholder per se. In some states, and Roger, you probably know this better than I do, but I've served on several national nonprofits and just stepped down as chair of one of them. The interesting stakeholder who has standing and will take action, but is quite rare, is often the attorney general of the state in which you're incorporated, right? So, because there is no shareholder. So someone can step in and say, wait a minute, board, you are self-dealing. So all the rules of, duty of care and duty of loyalty, apply, except it's mission centric. And so the feedback loop here is that the board is perpetuating itself. There's no one voting unless there's some other provision to have a different board. The board is simply perpetuating itself in most nonprofits. And there is no single arbiter outside of the board who votes, can block, can propose. And so you have fewer levers of input to either force change or compel a board to do different things in a nonprofit. There's other ways, right? There's often a founder who, is important, and then there's, stakeholders or funders. So it's more of a give and take if there's no contract. And I think, by the way, when even more dust settles and we have clear view of this picture, we will realize that the original board, didn't have these pressure points of input, right? So if there had been somehow an activist stakeholder, or there had been a contract provided that they had to, tell X group of people who were a cohort of funders what they were doing in the following ways and get feedback, you probably would have seen that board evolve differently, because there was no one available as a practical matter, except for Sam Altman, so he owns some of this, to call out the board and say, hey, so you guys were really a wonderful board for 2015, maybe for 2016. Have any of you had any activity with an enterprise worth $100 billion or more? Have any of you managed a P&L of more than $500 million? Have any of you been the CEO of a publicly traded or a very large, and someone in a traditional stakeholder environment, certainly a shareholder environment, would have asked that question. They would have said, no. And if they were a private company in a traditional VC world, that board would have been evolved, right? But instead, to your point, they had critical funders who then had that moment at the table. And so I don't think it requires a nefarious conspiracy theory to say, oh my gosh, they were handing over, all this. It's just that was who was at the table. And they said, we'd really like to, and then they had, outsized influence moving forward. So anyway, maybe that's not a great answer to anything, but it is, I think, a setup for the main point, which is don't do the structure in the future. I think actually, I think you're much better off with like a public benefit corporation with specific guidelines, or even a limited liability company with an operating
Exactly. You could do the same.
So you and I both know the traditional startup world is all C Corps, Delaware, there's a path, but the evolution of limited liability companies is a wonderful thing. Over the last 20 years, LLCs are the artist's blank canvas for great lawyers. You can construct almost anything you want that is well documented, well accepted, easy to litigate. There's no, oh, what will they do with it? Like a limited liability company, I think, in this particular story, and it's unfair to look back and second guess, probably would have been a better, more versatile vehicle that would have highlighted kind of more of the specificity that was lacking. So when someone hands a limited liability company a bunch of money, you have to account for it. Something has to happen where you say you either got a piece of the LLC, or this is a contract with the right. You just can't take $15 million from a billionaire if you're a limited liability company, at least if you're running correctly. You can take $15 million from a billionaire if you're a 501c3 and simply say, thank you for the gift. And I think that's the structural failing. There was no natural default inclination to say, we should really, what's he getting in exchange for this? In fact, in the 501c3 world, that's maybe a red flag. You're not actually necessarily supposed to say that when a donor hands you 15 million, right?
You can't have private inurement. It's part of one of the things.
Exactly. Yeah. Instead, you're saying, well, what is he hoping to advance that is consistent with our mission? And it ends up being as gray as it turned out to be. Sorry, go ahead.
He could have documented. I mean, we're using 2020 hindsight now, but honestly, this could have been documented a little bit better. But what do you think about this, Dan? Do you think it should have been a benefit corporation? Would we have avoided a lot of these problems?
Yeah. I think couple things. It would have avoided several of the problems, because you could have had a mixed mission that was doing exactly, if you go to the OpenAI website, they talk about their nonprofit goals and when they spun up the capped for-profit entity and how they hope to therefore keep the nonprofit at the center. They get a little bit in the legal technicalities, but by their own description, if you read that without reading what solution they used, you would have thought, oh, they're describing a public benefit corporation, where the public benefit corporation can choose to create and craft its own set of duties and obligations and say, for example, we will not profit maximize under these circumstances, but instead will, engage in super funding of safety protocols or, basic income research, like whatever they think was the offsetting component to the existential risk. And you don't have the problem you would have in a for-profit, which is it's in flux, obviously, in the last 10 years, but the shareholders in a traditional for-profit entity, whether it be a C Corp or otherwise, have a sort of, especially in the United States, supremacy over any other, less formal stakeholder. Now, you can cram anything into that if you think long-term enough, right? You're like, well, we're really looking out for the environment and spending a lot on environmental mitigation, even though our shareholders are a little unhappy with that because we want to exist in 100 years and, we're making sure that happens. So you have a lot of room in the traditional, fiduciary format. But if you were a B Corp, they simply could have spelled out what they have on their website now in advance, and they would have had owners, right? So this is the critical difference. Like the B Corp would have had shareholders of one sort or another, and they would have had a set of expectations. And then in that environment, Musk would have a lot more traction, I think,
Well,
for his plan.
absolutely.
I mean,
Might
like
have a
the
security story.
contract claim, there's no written contract, it's a long term,
Yeah.
like that's hard, right? The fiduciary claim, also complicated. They would have violated any number of, laws and IRS regs if they had taken the money and said, okay, here's an email. In exchange for this money, Mr. Musk, we're going to deliver to you the following thing that if they were, to your earlier point, if they were beneficial to him directly, would have been inappropriate. If it was loosey-goosey, they should have done a sponsored project. So, people sometimes forget, Stanford is a gigantic 501c3, right?
Mhm.
Educational. So that's our category. And yet we have perfected the formalization of engaging with all sorts of third parties who give money to the organization, and we formalize. Sometimes we don't. Like the law school actually gets lots of gifts where it's intentional and directional. It's like, hey, thanks for the gift for the Rock Center, Arthur
Yeah.
Rock, and here's kind of what we're going to do. And we have an advisory board, but there were no deliverables. That was not a sponsored project. Whereas in
No,
engineering, you might get a sponsored project.
gotcha. Well, but the concept of a fiscal sponsor is not novel or unusual at all. So, and as you look at this, you kind of wonder, again, we're using 2020 hindsight, but you kind of say, did you talk to anybody? Did you have any experts? I mean, on any of this? So that brings me to kind of the crux of this. What are the lessons from this? And let me give you kind of my takeaways. I look at
Sure.
this and it's not a good example, but it is a horrible warning. So here's the warning to boards is you should have expert advice when you can, including from your lawyers on how to do stuff. You might want to socialize some things before you take those actions to see how they're, before all your employees resign because they don't like your action. You definitely want to get legal counsel. You might want to have people on your board that really understand a broader array of what's going to happen. What are your takeaways from this in terms of lessons for companies?
Yeah, so they're consistent with yours. I would add to your first point, you want specialized experts. And so here's something that I really like about the current gestalt in most startups. And by the way, the average founder of a Silicon Valley-based venture-funded startup is actually in their late 30s, not in their early 20s. But let's, for the moment, kind of imagine the stereotypical tends to be a younger cohort. You didn't quite finish your PhD and instead decide to launch your startup out of Stanford, et cetera. Here's something that is culturally different. There's lots of good studies about this. And I think it's 95% great. Cultural differences, both generational and then also people who are tech oriented. I can figure it out. I can figure out not only what the rules are, but I can then figure out a hack to make it work better because I'm a smart and diligent person. And this self-help thing, which, my oldest is engineer at CU Boulder last year, ME, double, and all his life, whenever he's confronted with something, he goes to YouTube to figure out it first. I'm like, well, I can tell. He's like, nah, let me consult YouTube, right? So, and YouTube will range from like the silly advice to like, wow, that guy should be a lecturer at Stanford, right? And whatever it might be. There's a long setup for something that I think is a cautionary tale for startup entrepreneurs and anyone engaging in something like this. It feels like you can, if you spend a few hours and you're smart and well-educated, it feels like you can learn most of what you need to know about corporate structure, about setup, about all these things by going online and reading some really great blogs, right? Like Andreessen's old blog, P. Marca, right? It's a great blog. It's got great insight. But here's the reality. There are some areas like quantum computing, cryptography. There are some things where after the first 50 hours, you think you know enough. And then in the next 50 hours, you realize you don't know nearly enough. And then the next 1,000 hours, you realize you'll never know enough. This subspecialty of law is, I think, the top practitioners number less than 100. I hate to say that. You're among them. I wouldn't say that if you weren't, but like the very top practitioners who then have another several hundred people under them. So that's great too. But the very pinnacle of solving very hard corporate structural problems in a fast-moving, high capital, high value environment, there are very few people who know how to do that well. And 99% of it is pretty learnable by someone who's smart and spends 100 hours, but it's the 1% that will make all the difference. And that's why you should find not just your cousin's husband who's a pretty good lawyer from wherever, who doesn't do startup stuff. That's great. I'm glad you're talking to a lawyer, but you need to find a subspecialist who does what you do, and most of them are in Silicon Valley, as we know. So, or maybe in New York. And if you don't do that, there's a good chance that you'll be okay. But there's also, right, like it may not matter, but that's probably not a great story. It doesn't matter because you didn't raise money or you raised just enough. Yeah, but if you are building something that is either world changing or aspires to be or is novel or is going to be a rocket ship, you need the very, very best. So anyway, that's my number one takeaway. And I talk to students all the time. People come to office hours at Stanford, the law school, and they're like, well, I figured this out and I went online and I did the blah, 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 and I'm not going to do a lawyer yet. I said, ooh, you should. Your idea is great and it could change the world. But if it is actually going to be in the process of changing the world, it has to be perfect built. So anyway, that's a lot. You're not allowed to do that commercial. And it's not just for you. It's for the 100 other, that fall in the category.
No, I get you.
That's the number one piece of advice. The other piece of advice, by the way, is put everything as you're forming things. Reduce the conversations and the interactions at each step into writing, which is now not the norm among most people. They'll do it as an email or something, but you need to reduce it into writing, not so much because that's a contractually savvy way to proceed, but rather because it helps highlight in today's fast-moving environment that tends to be very brief in communication, actual differences that remain. So, there may not have actually been, in my opinion, a true meeting of the minds with Altman and Musk, even in the early stages. Like, Musk felt that this was this problem and that he was giving this money and he was promised X. But perhaps Altman really had his own vision of that, and they acknowledged that they worked and talked together many times, but it is perfectly reasonable. And the reason recovering lawyers and lawyers, like we like things reduced to writing, is it gives an opportunity for the parties to say, no, oh, no, that's not what I meant. Oh, really? Oh, gosh, I thought that's what you meant. And you sort it out. So if you are in this environment at all, you should reduce at certain intervals, whatever it is you think you as co-founders, as founders and friends and family funders, whatever it is, reduce it to writing, even if it's not for contract purposes, just so someone can raise their hand and say, oh, no, I didn't mean that. And then you can do what you want with that, right? Then you have some choices, but it's nice to know when you actually are not on the same page. And we say page because you have to read it and it has to be on the page.
Literally on the same page.
Yeah. And Roger, I don't know how you feel about that, but that's like just as a practical, even among co-founders, as people are building the very early stages of companies, co-CEOs is always a red flag for me. I'm like, ooh. But the thing that you realize with often co-CEOs is that they had a conversation about when it'll change and how it'll change. And if you put them in separate rooms and said, tell me your conversation, you wrote down the 10 points, you'll come back and 50% of that will not line up. And it's not because they're bad people. It's not because they meant to deceive each other. It's just kind of human nature. And so I have on many occasions said, sit over there and write down the circumstances under which you go from co-CEO to one CEO, what that looks like, what the trigger is, how it works. And it's they're like, oh, we just need 5 minutes. 2 hours later.
Yeah.
But that I'd rather they spend the 2 hours now than have a problem later. Yeah.
Yeah, no, you're preaching to the choir. And so I want to be just 2 minutes. I have one last question for you. I can't let you get away without asking you about this because your area of expertise includes the legal and social impact of autonomous AI robotic systems. And Elon Musk makes a very, very big claim that, like I say, AI is a very dangerous thing in the hands of a for-profit company. It's an existential threat. So tell me, what is the future of AI? How scared should we be of this? Is this a good thing? Is this a bad thing? Should it be regulated? I know that's a huge question for a short answer, but I'm just curious as to your reaction.
Yeah. So I'm not quite where Elon Musk is. I do think any extraordinarily powerful technology has some components of an existential risk. So I don't think that notion is crazy. But the briefest answer I'll give you. So I worked with Cliff Nass at Stanford. He was in the communications department, but also worked in computer science, and Sebastian Thrun early on. So that I was brought into that world because of autonomous vehicles. And so here's my take. Anything that amplifies the capacity of a human either makes them faster, smarter, or more scaled, meaning even a pulley. So early technology, pulleys made humans more effectively strong, right? Okay, so any technology that does that, I think you need to pay attention to what the humans are going to do with the technology in an unanticipated way, and what it might enable, what it might promote, what it might accelerate, what it might magnify. And so social media is a great example, right? So the isolation of communication, echo chamber effects, all some of the downsides of social media were simply an amplification of what humans were inclined to do, and the technology facilitated it. I have roughly the same view in the short term. I'm not worried about like master general AI real soon. Everyone I know who I talk to thinks it's at least 5 to 10 years away. So it's not my 10-year minimum worry, but here's what I do worry about. If you look at LLMs, so I'll give you, I don't worry about this particular scenario, but I'll give you the example. If you amplify some of the sometimes best, but in exaggerated form, worst behaviors by humans, what are those things that like LLMs or generative AI or ChatGPT 7 might do? And an example would be, it's a silly example, but I do it just to make the point. I'm not worried about the AI going around killing people. I'm worried about the cult that rises around answers of certain questions to an LLM that generates like a fervor of some sort, right? Like it's the human behavior that I'm much more concerned about, that will be provoked, exaggerated, amplified, accelerated by the technology. And I don't know exactly what that's going to look like, but you can draw analogies from cars, from guns, but I'm not saying AI is a gun, from social media, and then even the early stages of AI, where you can now customize cons and scams in a way at scale that you couldn't have done before right now using large language models. So that's actually, I think the thing that we should worry about is, what will humans do that will surprise us in these next 5 years on the back of something that maybe the twist on this will be that they think the AI tells them to do. And all the protections we have in place, the current ones, which are for the obvious things, they don't actually count for that, right? Not particularly. So anyway, I don't think, I think OpenAI's original mission was a great one. And I think they can kind of get back there a little bit. We'll see how that litigation goes, but I suspect it will prompt some changes, and we will see, since there's a lot more scrutiny on the now new board of OpenAI, I think people will suddenly know a lot more about the balancing of fiduciary duties and how this whole capped for-profit entity works. And, that it takes 6 years for people to vest. Last thought was, I do think the goals were good, right? Most of this issue arises because you needed to incentivize people to stay at OpenAI instead of saying hopping to any number of other competitors who could give them a traditional option that has this path. And so you needed to create something that is fair, right, for compensating this extraordinary and rare talent. And there aren't a lot of constructs to do that, and this was one way to do it. But anything that grows so fast and is so valuable, if you're kind of a novel construct, is going to do it. And by the way, Altman and Musk and their cohorts at the time all kind of fell into the category of the genius self-help strategy, right? And I think that's 95% a good thing. It's a change in social structure to a certain extent, where like, let me see if I can be my own expert. But the 5% of the time where it goes really, really wrong is a problem. And I think OpenAI is maybe a tale of that, which is, I'm wishing in 2014, 15, and 16, they had gone to the super specialized. There were lawyers in that story, and I think they were very good lawyers in many ways, but there are probably a couple dozen people who could have sat down and said, oh, wow, what an intriguing legal complex challenge. Let me give you a few options. And they would have come up with something different, I think. I don't know if that's your opinion, but that's definitely my opinion. If you went back in time, consulted the right people, you would have a different structure. They'd have other problems, but they would not have had this one.
Yep, for sure. Okay, well, I want to thank you, Daniel. This is Roger Royce with the 10,000 Startups podcast. We've been talking to F. Daniel Siciliano. He's the co-founder and CEO of Nikkl and an authority on corporate governance and compliance. We've just finished a lively discussion about the lessons from OpenAI and Musk v. Altman. So thanks again, Daniel. And again, Roger Royce, 10,000 Startups. We'll see you next time.
Thanks.